let's just set the scene for a moment. Picture this. It's September 17th, 2004, morning rush, maybe 8:15 a.m.
Okay.
And you've got these two men on a two-wheeler, just navigating traffic. Then suddenly they're cut off.
An ambush.
A complete ambush. Rivals, guns drawn, and just like that, in broad daylight, both men are executed. A really visceral double murder, all fueled by this old-school election rivalry.
And it sounds like it should be an open and shut case, right? But the legal story here, the case of Rajesh Yadav v. State of UP, was anything but.
It dragged on for 18 years.
18 years. And by the time it got to the Supreme Court in 2022, the whole case was, well, it was hanging by a thread.
Why? What went so wrong?
For starters, the main independent witness, he turned hostile.
Meaning he changed his story to help the accused.
Exactly. And the police officer, the investigating officer in charge of the whole thing, he literally vanished mid-trial.
So for this deep dive, we're doing something a bit different. Think of it as, I don't know, true crime meets the high court.
Mm-hmm.
We're going to decode how the Supreme Court managed to uphold a life sentence when the case was just completely falling apart.
It's a real masterclass in jurisprudence, and it all starts with the witnesses. Since the independent guy flipped, the prosecution had to lean hard on the victim's nephew. He was riding on the back of the bike.
Okay, which brings up the most obvious defense argument. He's family. Of course he's going to point the finger at the rivals.
Of course. They immediately labeled him an interested witness. The idea being, he's biased. He has a personal motive to lie just to get a conviction.
But the court didn't buy that.
Not at all. And this is where it gets really sharp. They drew a massive distinction between an interested witness and a related witness.
What's the actual difference, legally speaking?
An interested witness has a motive to frame someone falsely, but a related witness is just family. And the court's logic, which they pulled from the Namdeo case, is pretty powerful. Think about it. If your relative is murdered right in front of your eyes, are you going to let the real killer get away just to frame some old enemy?
No, you want the person who actually did it.
You want the actual guy. You'd be the least likely person to screen the real killer. So in that context, being a relative actually makes you a more, not less, credible witness.
The court calls them natural witnesses.
Exactly. Your presence is natural, and your desire for the real truth is natural.
Okay, but the defense didn't just stop of him. They also went after the bystanders, some people at a tea shop nearby. They called them chance witnesses.
Yeah, arguing it was just too convenient that they happened to be there.
Which seems a little ridiculous.
The court thought so too. I mean, they had to point out that in India, streets are crowded, people are everywhere. A tea shop isn't some suspicious anomaly. It's a natural feature of the landscape. They're natural observers.
You can't just throw out testimony because reality is messy.
Right.
But we have to talk about the disappearing cop. The investigating officer. You said he just vanished.
Completely. He gave some testimony, then just stopped showing up for cross-examination. And the defense, of course, they jumped all over that.
I mean, that seems like a pretty strong point. If you can't finish cross-examining the lead investigator, how is that a fair trial?
Usually it isn't. But the court pulled up Section 33 of the Evidence Act. It basically says if a witness becomes unavailable and missing counts, their previous testimony can still be used, but only if the other side already had a reasonable chance to cross-examine them.
So because he answered some questions before he did his vanishing act, his evidence still counted.
Precisely. The court said the IO isn't indispensable if you have other solid evidence, like the nephew's testimony. You work with what you have.
It really sounds like the judges were just losing their patience with all these procedural games.
Oh, they were furious. The tone of the judgment completely shifts. They referenced an older case, Vinod Kumar, and basically screamed, "Awake! Arise!" at the trial judges.
Awake! Arise! Why such strong language?
Because of the massive delays between the chief examination, when a witness first tells their story, and the cross-examination. In this case, defense lawyers kept getting adjournments for months.
And in those months, anything can happen.
Everything can happen. That's when witnesses get threatened. That's when they get bought off. The court was crystal clear. These long adjournments aren't a strategy. They're a weapon to destroy a fair trial.
So if we're pulling this all together, what are the big takeaways? For the public, say.
It's reassurance. If you witness a crime involving a loved one, your testimony matters. You're a natural witness, and being related doesn't invalidate your truth.
And for the lawyers listening in.
The message is clear. The era of weaponizing adjournments is over. The Supreme Court is not going to tolerate strategic delays designed to break witnesses anymore.
We'll leave you with one last idea from the judgment, something to chew on. It's called the prudent man test.
Right. It's this important reminder that the standard of proof in a courtroom isn't absolute mathematical certainty. It's about probability. The question is, does the evidence tell a story that a common, prudent person would believe and be willing to act upon? If the answer is yes, well, that's enough for justice.